All right, we're back. Sorry about that, guys. We'll just wait a few minutes to get everyone in here. I'm such a noob at this OBS studio, so just bear with me here. I'm sorry. I knew this would probably happen. All right, this is pretty cool. All right, if you guys can hear me pretty good, type a 1 in the chat for me, please. Okay, excellent. Excellent, excellent. Now, can you guys see this OBS pop up on the screen? Can you guys see that? All right, so I'll minimize. Well, I don't think I want to minimize it. Let's put it out here, I guess. All right, very cool. Can't believe I haven't used this feature before, OBS Studio. Super cool. So I guess this is starting here pretty soon. So what we're going to be watching today, guys, we're going to be watching the Pima County Superior Court. It's a hearing about. Let me take a look at my notes here real quick. I don't want to misspeak here. All right. So this hearing has to do with modifying conditions of release to make sure that Pima County never lets Lane Myers, and I'll talk to you about who he is in a minute in case you haven't heard of him or what's been going on lately with regarding him, to make sure that he stays in jail and remains a political prisoner. Of course, that's not what they're going to say out loud, but I think once you get caught up with what's going on, you'll see things my way here. And basically, this is for Lane Myers, and I'll get to who he is here in a minute. It's for him posting publicly available information. So if you have heard of this Lane Myers debacle that's been going on over the last couple of months, type a 1 in the chat for me, please, just so I can get a lay of the land here.
If you are the victim of a crime with a case pending before this court, you are advised that you have rights to justice and due process under Arizona law that, among other things, includes the right to be treated with fairness, respect, and dignity, to a speedy trial and a prompt and final conclusion of the case, to be present at court proceedings to choose whether or not to be interviewed by the defendant or his attorney, to be heard before the court makes a decision on release, negotiation of a plea, scheduling, and sentencing, and to receive restitution from persons convicted of causing your loss. If you've not already been provided with a written statement of victim's rights, please contact the prosecutor's office. With that, we will get started this afternoon. Let's go on the record in the matter of State of Arizona versus Lane Jeffrey Myers, CR 2025-1060. Parties' appearances, we'll start with the state.
Rachel Stiles for the state, and Your Honor, the victim is present.
Okay. Mr. Myers, your appearance?
What's that?
Your appearance?
I'm here.
You got to state your appearance.
Want me to stand up?
You don't have to stand up. Just say your name that you're here.
I'm Lane Myers and I'm here.
All right. And then we have Mr. Parvin as your not standby,
Advisory.
advisory council. Thank you.
She didn't provide anything you told her to provide me.
Hold on, we're not there yet. A couple things I want to address. First one, computer on.
Can you guys hear what's going on?
You know
with
that
this
information
video?
on the government website
Hold on.
Just let him talk.
is not personal information?
Hey, stop talking. I need to
We're gonna get
open up
through
my
every-
computer first, okay?
We're
I
gonna
need to
get
have
through
everything.
today, because you know, we have all afternoon. Everything will be done today. We just wait for our turn.
I need to remind them early and often. Somehow they don't know that information on a government website is personal information.
You're gonna, if you want a trial, you'll get your trial. But just
State employees don't even know they're state employees.
Hold on just a minute, Mr. Myers. I just gotta.
I'd like you to put on the record how you think you're above the Supreme Court and you can overrule 122H. I want that on the record today, because I got this order from you today in jail that says you overruled 122H. You don't have that authority. So I'd like you to speak into the record what gives you the authority over the Supreme Court.
can you let him? He's gonna give you time to make all your arguments. Can you let him open his computer and at least look over what's going on today?
Not really. I'm sitting in jail with no bond for some bullshit. And he denied the slap, and it's
Oh, you gotta stop talking. You can't be in here if you're gonna talk like that, okay? I haven't asked to hear you speak yet. I'm opening my computer so that it's working, all right? Understood? And I'm not gonna let you up here and talk if you can't pay attention and follow the rules.
the rules apply to you too.
Please let him.
You gotta stop, or I'm not gonna let you be in the courtroom.
He's gonna give you a chance to speak. You'll see. I'm gonna give you lots of
Just
time.
hold on. All right. So the court has previously ruled that no private recording devices are allowed in today's hearing, per my previous order. Like almost all hearings that I conduct, this hearing is being live streamed over the court's YouTube channel. It's accessible through our Pima County Superior Court website. It is a very good working, clear way to project the proceedings. It's hooked up to our microphones and everyone can hear it well. In addition, the courtroom itself is open to the public under Article 2, Section 11 of the Arizona Constitution, meaning anyone who abides by the rules and is polite can sit at the courtroom and watch the proceedings. All right, so we are here first on the state's motion to modify conditions of release, and that was filed on March 18th. It's called amended motion to modify defendant's conditions of release, and then we have Mr. Myers' response filed that same day, entitled a response to motion to modify conditions. In addition, I am advised that in case IC 003692 that a bond eligibility hearing was held earlier in the week in that case, and that the court in that case found that the defendant's release conditions were revoked and the defendant is held without bond in that case. And we find Mr. Myers in custody today. So just to start out, Mr. Myers, you're still on release conditions in this case, so you're not getting any credit for time in jail on this case. If the court imposes a bond in this case and you're held on that bond, then you'd be getting credit for time in jail. If you are convicted and are sentenced to prison,
I won't be.
hold on, and sentenced to prison, then you get credit for time served. So
I know
Just
how it works.
hold on, just listen. So, Mr. Myers, if you're, as you will recall, what we discussed at the last hearing, the state has alleged priors, which if they're able to prove those priors and you're convicted of a felony in this case, then you would be prison only. I wouldn't have any discretion whether to send you to prison or to.
Be going to prison.
Hold on. And if you're sentenced to prison and you don't have a bond in this case, you wouldn't get any credit, even though you're in custody on another case. So that's a very important thing for you to understand. Mr. Alves, would you agree that that's the state of the law?
Yes, Your Honor.
Okay. So, Mr. Myers, the first question I want to ask you is whether you want me to impose a bond so that you get credit in this CR number for the time that you spend in the Pima County Jail.
You told me that last week, at the hearing, you told me that we were going to come here today and we were going to discuss, her motion. In my motion.
Okay.
Like I
so,
said would
so,
happen.
so I asked you a question, and
You want me to agree to a bond?
I didn't say to agree. I want to know whether you want a bond so that you get credit. You don't have to, but you have that option to do so.
Wouldn't that be admitting to the violations?
No.
No. It's just bond. That would not go before the jury.
So you could put like $100 just for like technical reasons or something?
Yes, that's what I was going to ask for if I were still your attorney.
Just
Yes,
for
yes.
paperwork reasons.
Correct.
Well, I think they're going to drop the charges in the next few days. If they were smart.
Okay, that wasn't my question. Again, I'm trying to ask you a question and trying to get you to interact with you. You're having a hard time listening to
I'm
me.
having a hard time because you told her, you gave her a court order and she didn't obey
Okay,
it.
we're still,
Separate issue. It's just a question to help you out for this one technical issue.
Do it.
okay, so you want the court to impose a bond, and
I'm not admitting guilt.
No, you're not.
no, it's not admission of guilt. What date was he taken into custody? That
It was
Last
the
hearing.
20th at the last hearing when we did the Feretta motion, or when you granted his right to represent.
No.
himself.
It was the next day. It was not that day. You gave me the right to represent myself on a Wednesday, and then we came back on a Thursday, and that's when they put these bogus charges on me.
It's March 20th.
March 20th.
Mark.
March 21st.
No, 20th.
March 20th is the
20th is
Thursday.
better for you. It's an extra day.
What I'm saying is are we actually like talking about Wednesday or Thursday? 'Cause remember, the first day I came, we had the little hearing and I went home. The next day I came, I didn't go home.
Okay.
Where I should
Last
be.
Thursday was the 20th.
Thank you.
Okay. And Ms. Stiles, what is the amount, the defendant's asked for a nominal bond. What would your position be on that?
Your Honor, I would ask for no less than a $5,000 bond, just given the nature of the charges. He is being held without bond in the other matter, though, so regardless of how much, he's not going to be able to post bond and get out of custody.
Until
All right.
you drop the charges.
Hold on. Mr. Myers, I'm inclined to post a $500 bond. Is that something you could manage?
Well, I mean, it doesn't matter because they're playing games.
Okay. So as to that release condition, I'm going to order the defendant held on $500 bond in this CR matter effective back to March 20th. So now you're getting credit back from the date of your arrest. The next question would be
All those days will count towards my unlawful imprisonment?
correct.
Thank you.
All right. Next, I do want to talk about other release conditions, but before we get there, there are a couple things I want to discuss. So at the last hearing, I just allowed you, we had an interaction back and forth, and you had asked to represent yourself, and after finding that you knowingly, voluntarily, and intelligently waived your right to counsel, I allowed you to represent yourself. And today you're representing yourself, but you're having a hard time behaving yourself. And one requirement of representing yourself is you have to maintain the proper decorum in court. And if you can't do that, then I can't allow you to represent yourself. So self-representation requires you to appear and act properly in the courtroom. Do you understand that? Okay.
I'm a little frustrated. I apologize. I know
All
it's
right.
not you. It's just, this is all a big joke.
So, Mr. Myers, I'll continue to ask
It is
you
a joke.
that if you want to continue to represent yourself. You do have the right
I know.
to request representation, and then Mr. Parvin could step in and be your attorney. As we get closer to trial, it would be harder for him to do so if he thinks that you're preparing, and then you try to ask him to step in at the last
That's kind of
moment.
the thing. It's like we got to kind of like figure out how well I can prepare. If the state's not even going to provide me the things you ordered them to provide me, it's hard to prepare for anything.
Right. We'll talk about that, and I promise we'll get to disclosure.
So I could just at any time request. My thing is I'm about to appeal your. I don't even know what you were thinking in that special slap, but I'm about to file ASU's about to take the case and file a special action.
Okay.
Get
So
slap.
the way that
I don't know if they can do that if I'm not representing myself yet.
well, that would be before the Court of Appeals. My ruling applies to the case before me.
So I don't know if they can. I don't know if that's contingent on me being pro se in this case. They're willing to do it. I don't know if that's something that they can do. Like I said, it's all just been talked about this morning. I talked to ASU this morning. I'll know more later after this hearing. They're going to take the case and fight it because they know what's going on. So they're going to do the special action of the slap. I don't know if I have to remain pro se in the superior court for them to do that, because then it's like they're helping me as a pro se or whatever. So that's one thing that I don't even know how to get a hold of you if I wanted to get. So let's say Monday or Tuesday I get more information on that, and then they say, yeah, you can go back to Parvin and we can still help you. How would I even, so what, write you a note? I mean, because that's kind of like the thing here is I'm trying to get a feel for, because obviously, sir, when I applied, put in a notice and we had the hearing about representing myself, that was under the expectation is I'd be at home with Westlaw, my wife's through the lawyer, and Parvin helping me. Obviously, the state also knows that if I'm at home with my wife who's a lawyer and Parvin helping me, they're going to lose the case. So they wanted to play dirty games and get me in jail, and now they won't disclose. So it's like, well, if I have to rely on you, sir, you're the top dog here. You're the man with the power, and it's kind of contingent on how adamant you are with, because you told me at the first hearing it's too early for a motion to compel, right? Well, I've been dealing with these people for 9 months while they've been retaliating against me.
Hold on. I'll get to your motion to compel and disclosure, but I want to keep.
Well, it's kind of like I have to make my decision on if I can represent myself based on the quality of legal. Based on my ability to prepare. And when they're telling me at the jail is, well, which it might change now that you put the $500 bond, but I've been in jail for a week, and they told me I'm not even allowed to use the law library because I'm not in jail on those charges. I'm on jail on different charges where Parvin's my lawyer, right? So now I don't know if now that you put a bond, because they said I can only do it with a court order. I was under the impression you gave me a court order last week that said I could represent myself.
Right.
And now they're saying, well, you can't represent yourself without a court order. I was like, well, I got one last week.
All right.
So I haven't been able to do anything.
All right, couple things. Let's just talk about your representation. So
it's contingent on the equality of the. I can
understand.
If I can represent myself with confidence and have the documents, just like if I was at home, that's one thing. But if the state's going to jerk me around and not put, then I can't actually prepare, and I'm relying on you to enforce that.
So let's just talk through this. So, as to representation in this case before me, you represent yourself.
Aren't they going to come together though at some point?
Probably.
Okay. Well, then I have to reapply to apply for those specific charges?
Correct.
Okay.
All right. So that is not, it's in the work, that system's in the works, but it's not to the point where it's assigned to me yet.
Will it all become the same case number?
No, separate case numbers, and either side can ask to consolidate them. So, but let's talk about this. In this CR number, you represent yourself.
The one that I'm already approved.
Yes, correct.
Right.
The one we're here on today.
14 charges from.
Right. So in that case, you represent yourself. You can have an arrangement with the ASU Law School. Whether they want to represent you or not is between you and them.
Not for criminal.
Not in this case.
Right.
But they can, if they file a special action in the Court of Appeals, that's before the Court of Appeals. I'm not involved in that. The only thing is, at the same time, you want a speedy trial. Now, if the Court of Appeals were to issue a stay because they want to decide that issue,
they're gonna.
Then the case couldn't go to trial. Does that make sense? Okay.
Because it should have been thrown out by you.
Okay. So just be advised that I'm proceeding in my case. If the Court of Appeals issues a stay.
Yeah, they know that personal information can't be on a government website.
Okay, hold on. If they issue a stay, it could affect the schedule in this case.
I don't care. This shit should
All
have
right,
been dismissed.
that's fine. All right. So, but you understand that your arrangement with the ASU Law School, I'm not involved in that. Okay.
like I said, I'm not saying that they came here told me to talk to you about that. I'm saying that with the little bit of information I came with today, I haven't even had a chance to ask them because I didn't, we don't know what's going to happen today. I don't know if you're going to, I'm waiting to see, because I mean, you already, I don't even know what you were thinking, but now I'm going to see if you're going to actually uphold your own court orders before I decide to bring Parvin back or not. Because if you're going to actually enforce the Rule 15s on these people, then maybe I can represent myself. But if you're just going to let them get away with everything they've been getting away with up to this point, then it's already a mistrial anyways.
Okay. So let's talk about disclosure then. Ms. Alves, what's the state of disclosure in this case?
Your Honor, the disclosure all went out to Mr. Parvin prior to him representing himself. So then Mr. Parvin should be providing that to him.
That's not correct.
I do believe that he's had some of the disclosure because he's been reading it online, because he's been streaming.
She has the floor. Just let her talk.
So I know he's not without anything because he's been actively reading it
I have
to
the grand
people.
jury transcript. That's not disclosure.
Hold on, Mr. Myers, don't interrupt. I'm talking to her. I'll let you respond. Again, if you can't control yourself,
Lane does need to
just let. All right, just
So
let
you're
her.
saying let her
I'd like
talk
to see
and
this
then
move forward.
Then
you
I'll
come
go back to you.
Okay.
Correct.
I don't need to
Do you
object.
remember how that hearing went and I waited to the next day to make argument and it was,
Okay.
with exceptions?
So,
Go ahead, Ms. Stiles.
so the disclosure was given to Mr. Parvin while he was still the attorney prior to it switching to Mr. Myers representing himself. We now have additional disclosure that's coming in because of the new charges, but he does not represent himself on that case. That goes to Mr. Parvin. So that disclosure is still going to Mr. Parvin. So we are, in my office, we got to figure out what to do about that because he's representing himself in one case but has the attorney in the other, because I also don't want to be communicating with a represented party on a case where he has the lawyer. So I need some clarification on if I need to be sending the disclosure additionally to Mr. Myers. My understanding before is that Parvin was also helping with that, but I do understand that Mr. Myers has a right to have it sent to him directly when he's representing himself. So we just need some of that. As far as there's a lot of media in this case, and so I have to figure that out with the jail and how to get that so Mr. Myers is able to then review his media. That also goes with their protocols for safety and things like that at the jail and their security issues.
And the media, are they put on DVDs or what's the medium you use?
It just depends. A lot of times we put it on disk. We might be able to put it on a flash drive. So we'll just coordinate. I don't know how the jail will want us to give that to them so that they can then make it available to Mr. Myers to review. And so that's something I have to work out with the jail. But once again, the issue is he's representing himself in one case but not the other, and so that's creating some confusion. But all the disclosure I say that we have sent to Mr. Parvin already.
And the disclosure would include police reports, which I assume have been disclosed.
Yes.
And then there are like voicemail recordings and then postings on YouTube, and that's the media you're talking about?
Yes.
All right. So, Mr. Myers, how would you want, so what Ms. Stiles is concerned about is, as to the disclosure, as to the new case, you're represented, so she can't communicate with you directly. So it would be unethical to do so. Go ahead. What do you want to say?
I want to say that this woman is a professional liar. First of all,
Hold on, Mr. Myers. We don't call people liars in court. Just make your argument.
What's the best way to say that if I believe? Okay, I know lying is a taboo word in court. Okay.
It is.
What is the best untruth, misleading?
Well, so the question is.
Because my thing is, last week we had a hearing, right? And I told you this was going to happen straight to your face last week, right? And she's trying to convolute the issue and gaslight the American people, right?
Okay, hold on, Mr. Myers. They've disclosed police.
What
disclosure
were we even talking about? Because I want to make sure we're clarifying exactly. Because disclosure is a big word, right?
Okay.
There's 20 charges with probably 500 more coming, and so the issue when in this hearing today, in the contents of this hearing, when I use the word disclosure, I'm talking about something very specific, and that very specific thing I'm talking about is last week. Okay. She is right. Maybe they sent disclosure before, but what I'm talking about is they filed a motion to modify the conditions of release. They then filed an amended motion to modify the conditions of release. Neither one of those motions included any exhibits of anything they were talking about. So therefore, last Thursday, we came in here and I said, I don't even know what they're accusing me of. And she said, oh, you should know. You make the videos. That I still have the right to be noticed. Now listen, I told you this before I got arrested that day, that in order to have this hearing today, I needed the disclosure specific to this hearing. I'm not talking about disclosure in general. I'm talking about in order to make arguments in this hearing today, I told you last Thursday to order, and that was what the motion to compel was for. It wasn't for the whole case generally. It was, we are having a hearing next Thursday to modify my conditions of release. Anything Rachel Stiles is going to bring up there, I need a copy of, even if I'm in the jail. You looked her straight in the face, and she goes, oh, yeah, we'll make sure he gets it at the jail. They haven't given me anything, not one piece of paper.
All right, hold on. So, Ms. Stiles, is the disclosure that was going to be addressed today the same disclosure that affects the new case? Is that what's going on?
Yes, Your Honor, and it was disclosed to Mr. Parvin, and it was then presented at the no bond hearing.
It was or was not?
It was.
Okay.
So we had the exhibits at the no bond hearing. We had the videos, the clips, videos played. So he's seen all of it because it was all at the hearing, and Mr. Parvin had that. And prior to that hearing, I also notified Mr. Parvin of what the times were for the clips so that he didn't have to sit there and watch the whole video and know what I was going to have the clips of. So I provided all that information to Mr. Parvin. The difference is when we were dealing with the hearing on the 20th, is at that time the new case had not yet started because the complaint hadn't been filed. So at that time, Mr. Myers was solely representing himself at the end of that hearing. But then, because then the complaint was filed, he was taken into custody, the new case began, and he was appointed Mr. Parvin. Then again, I had to communicate to Mr. Parvin, and because that disclosure is for that new case, I had to provide it to Mr. Parvin, who is his attorney.
Right.
And so that's the difference of what changed from the 20th.
Okay, so Mr. Myers, what Ms. Stiles is saying is that because you're represented in the new case, the rules of ethics require her to make disclosure to Mr. Parvin. I don't know why that's funny.
Ethics.
That's the rule.
She doesn't follow ethics.
Hold on, that's just the
Rule
rule.
3.8,
She's
special responsibilities of a prosecutor. Rule
hold on.
3.81 is don't prosecute without probable cause.
Okay, all right, Mr. Parvin.
Ethics 3.6,
Mr. Myers,
trial publicity.
again, we got to stay focused here. We're talking about the person to whom she has to make the disclosure.
And so why did you,
Go ahead.
I feel like these people are just talking in circles. All right, Your Honor, look.
Well-
At the last hearing, sir.
But she, hold on.
I get the nuances. Just let me. I see. There's multiple nuances here. All right. So I'm trying to articulate myself in the best way to understand the specific nuance that I'm talking about. I understand all those little. This is what I'm talking about, sir. What day was it? Because I don't have it in front of me. What day did they? It was like the Monday, the 17th or something. What day did they file the motion to modify conditions of release?
The 18th.
The 18th. Okay. They didn't include any exhibits with it. So whatever exhibits they had that day should have been included with the motion so even you could see them. And at the hearing, you had to order them to send them to you. You said, at the hearing, you said, I need anything we're going to talk about today, I need you to send me copies of, right? No, that should have been included in the motion. And it wasn't. So if it would have been included in the motion like it was supposed to, we wouldn't be talking in circles a week later.
Okay.
Because if they would have included, hey, we're filing this motion to modify conditions of release contingent upon this video, this timestamp, this, you wouldn't have had to ask her to provide it to you because you would have already had it. I wouldn't be talking in circles because I would have already had it before I went to jail. And we wouldn't be sitting here a week later with her having provided nothing, making excuses about Parvin this, Parvin that. Listen, you told her in open court, it doesn't matter if he's in jail, make sure he has it. Now all she has is excuses.
Okay. But again, there was an intervening event, which is that you were charged.
She knew that was there because she knew when I was going to walk out of court that day that I was going to get arrested.
No, there was no case pending. Once the case,
You knew I was getting arrested that day.
Hold on.
We talked about it. We said I was going to get arrested, and I even addressed it. And I said, if I go into custody, I apologize. When at the last meeting, or then at the last hearing, you knew I was getting arrested when I walked out in the hallway. That's why I was adamant and specifically saying, I'm coming back here in 1 week, and when I go to jail right now in 10 minutes, I have nothing to prepare for. you ordered her to turn the whatever we're going to bring up today, order to me, right? And you also said, make sure Mr. Myers has it. And then you told me if she doesn't provide it, we can continue and all that kind of stuff. Well, she hasn't provided it. And there's no nuance between the new case and the old case. Where's the disclosure that was attached to the motions to modify and the motion to amend, amended, the first one and then the amended? Those should have included exactly, and she didn't, that wasn't even a legally cognizant motion because it didn't even include the exhibit that she was arguing. And then, so that means that 18th, 19th, 20th, she's saying, oh, I gave it to Parvin because you weren't yet represented. I'm not letting this stuff fall into the black hole. She knew we had this hearing today, and she knew that you ordered her to make sure I came prepared today. And it's her responsibility as the prosecutor to ensure that I am served just like I'm required to serve her. So we can go into this little nuance about this. I don't want to hear that she didn't know she literally knew the charges were going to come when I walked out in the hall. So she should have been prepared knowing, hey, this guy's about to get arrested and he's going to still have this bond hearing next week. And my ethical duties as a prosecutor are to make sure he has this information so he comes prepared. I don't want to hear I gave it to Parvin and Parvin has kids and the jail wouldn't let him. I don't care. You gave her a court order. She didn't follow it.
Okay. So, Mr. Myers, first of all, I don't know when you're going to be arrested. I had no involvement. I know
I'm not saying you were involved, but we did talk about it.
We talked about it.
Cops were standing in the back of the room.
It was a possibility.
They were waiting for me at the back of the courtroom.
You got to let me talk.
I didn't even get to walk out of the court that day.
Well,
without going into jail.
Let me talk. At the time that we had the hearing, there was not another case pending. Once those charges were filed and you had a lawyer for that, she has to go through the lawyer.
On
that's
the new stuff.
Right. And that's
still the modified conditions of release hearing.
Okay. But you now have the stuff.
No, I don't.
All right. Mr. Parvin, what would the arrangements be for
nothing.
Hold on, for Mr. Myers to get this information?
May I speak on this issue?
Sure.
So, obviously, for the arrest, I was forwarding. Disclosure was going to me while before I was removed, and I would forward all emails. It's actually real simple, and Mr. Myers very clearly downloaded it because, as the state unfortunately mentioned, it's been
It's not unfortunate.
Well,
it's the rule 3.6.
Let him talk.
I'm explaining that's, I guess, further proof Mr. Myers did get the disclosure. So everything from media included, it was easily downloadable. At that point, it's a lot easier when Mr. Myers out of custody because I can forward the same media. He downloads it just like I do. Now, after Mr. Myers was brought into custody, I was appointed on this and it wasn't easy to get prepared that quickly for a hearing, but
right.
Pulled it off. I have to reveal a lot of disclosure. Most of it's in media format that I can't get to Mr. Myers at the jail. The jail's in lockdown half the time, which is a problem of its own. They did make an exception yesterday for me, thankfully, so I could talk to Mr. Myers even though he was in lockdown. But in general, it's very difficult. I've given Mr. Myers what I could in paper format. I brought a couple pages today that were emailed to me. There's not a lot of paper police reports. It is mostly media. I understand that the state is making arrangements for the law library so that can all be passed on to Mr. Myers. Obviously, I can no longer forward it to him in electronic form.
Okay. So, Mr. Myers, it sounds to me that the real problem is that this is in electronic media, and with you being in the jail, it's hard to get it to you.
Maybe they should let me out of jail.
That's a different issue.
Oh, well, they let kidnappers out that beat their pregnant wife.
Mr. Myers, again, you got to be respectful. You're not being respectful in court. Okay.
It goes both ways, though.
Hold on. No, we're talking. This is a technical problem of electronic media.
It's my life.
Mr. Myers, hold on. It's a technical problem of trying. Hold on. Just stop talking over me. The state is going to get you, and Mr. Parvin's going to work on getting you the media in jail. They just have to figure out how to do it.
And then the jail's going to say you can't do that.
Well, we'll have other hearings if that comes up. So
it'll be a mistrial either way.
So that's where we are on that. All right. So it's not that people are trying to do something to harm you. It's that it's physically difficult to get electronic media to a person in jail.
Then don't hold somebody in bond who should be out on bond. You don't have these problems.
All right. Well, we could address that down the road, but you're being held in the other case after our evidentiary hearings.
Virtually no reason at all. They had no reason.
Mr. Myers, you're showing that you're unable to represent yourself.
I'm unable to represent. Are you saying because of using the word bullshit?
Yeah, because you're just being disrespectful.
Are you saying that's not allowed in here?
No, okay, you can't talk like that. Just talk normally in normal English.
To be honest, my normal is probably not courtroom
Yeah, courtroom normal is we don't call people names and we don't use poor language like that. We just talk in a normal voice
No,
with
to
each
me,
other.
I use the F word and
Yeah, we don't use that.
ordering something at the grocery store.
Yeah,
so.
we don't use that in
I
court.
get it. I'm trying to work with
Okay.
you, and because some judges, BS might not, some might.
So I want to talk about a couple of other things we have in this case. I know you want to file a petition for special action relief in the Court of Appeals, and if they stay this, then they stay this. But you've also told me you want a speedy trial, and so
Well, I expected you to grant that, at least make him respond, because I don't even know what you were thinking. I haven't even seen a copy of your order either.
Hold on. Go to the higher court.
I know, but I'm saying, how come I haven't even got a copy of your order either?
it got mailed to you.
So I'm sitting in jail getting nothing.
Okay.
I can't even read it to talk to the ASU. I don't have it in my hand.
The people,
Good point.
Mr. Myers, the people that are working with you, they have copies. I can assure you that I've given copies to the correct people who are working with you for that.
For ASU?
Yes.
Okay,
The person who told me
okay.
they have a copy.
All right.
I can assure you that.
So I'm not going to, our next court hearing is on April 15th. And because we have the victims here today, I can also set that as a trial setting conference if no one objects. So we're going to be back in court on April 15th. And on that date, I want to set the trial date, but I want to tell you now what that date I'm going to set. So any objection to making that a trial setting
You're
conference?
saying that we're going to set it that day officially, but today we're going to broach it
Yeah, I'll just throw it out there.
informally.
Correct.
Okay.
Is that all right?
I have no objection to the April date being converted also to a trial setting date.
Okay.
Is it possible to start trial that day?
No. In part because if the other charges come through and you want to consolidate them, that's not going to happen that fast.
I'm giving him a week to dismiss them.
So the case management conference on April 15th will also be a trial setting conference. And the date I'm suggesting for trial is June 17th. My trial started on Tuesday. And we have that week.
It can't be any sooner? I'd like to start at April 16th.
So the speed trial time in your case runs August 11th. So I just have to set it by that date. I'm actually doing almost 2 months before that. So,
I appreciate it.
all right.
In Your Honor, I will note that I did speak to the victim, and that date is a conflict for them for something they already have that's already been
It's my rights.
rescheduled.
Defendant's rights overrule theirs.
So your right is by August 11th.
So they just need to look at their calendar. So
Yeah, that's why I'm not setting it today. So
So they get to jerk me around.
no, they're not jerking you around.
They've been jerking me. I'm sitting here in orange handcuffs for showing a government website.
So, Mr. Myers, the victim also has rights under the
Not the
victim.
victim. I'm the victim.
Hold on, the victim has rights under the Arizona
Alleged
Constitution.
victim. Let's use the right language here.
It's
Alleged
the word.
victim.
The word is victim in the Constitution.
It says right here, alleged victim.
All right,
I
that's
would
not
prefer-
a that's not a finding.
So you're
It's
saying
just-
that by saying that it doesn't indicate that you've already determined she's the victim? Because it
I haven't-
bothers me to hear somebody call somebody a victim who hasn't even been convicted.
that's just it's a legal term of art
Is
under
it
the Arizona
alleged victim?
It's not called alleged victim in the Arizona Constitution.
All right.
There's victims' rights.
I get it.
That doesn't. I don't say that before the jury.
Okay.
That's just like you're called the defendant. The state is called the state. They're just
I'm Lane
they're just labels. You're Lane Myers, but in legal things you're the
I'm not a
defendant.
defendant. I'm a victim
Okay, so
of unlawful prosecution.
so we set this. I'd like to set it for June 17th, but we'll have to see if that works for everybody. If not, then I'll set it in July. All right. Look at my list here.
How many days?
So it would be the 17th through the 20th, and
How
then
are we going to watch 49 hours of videos in that many days, in 8 hours at a time? That's 6 days of just watching videos.
so the rules of evidence would not allow.
We're gonna have
that.
rules. We're gonna have the rules of completeness. We're gonna watch every minute of every video I've ever made.
You're gonna have to file your own motions here.
Okay.
Motions
So-
I would file that might be
so-
different than you. But
We're not gonna take my videos out of context.
All right. There is a rule of completeness, but there's also a rule of relevance, and that it not be duplicative or wasteful of the jury's time. Those are both rules. You can look them up.
Even having trial is a waste of the jury's time.
All right. So that's what the schedule is. The next thing I want to talk about is release conditions. And I'll start with the state.
So we're gonna have the hearing, even though they haven't provided the disclosure.
You've already stipulated to a bond. I'm just talking about the release conditions.
The modified condition or whatever.
Yes.
So are we gonna have the little hearing?
we're just going to talk through that now. Ms. Stiles, currently the release conditions are the defendant have no contact of any kind with the victim or victim's family, the defendant not go to the victim's residence or workplace or victim's family workplace, and to take the videos of the victim down. What would the state's proposal be as to release conditions if they should be modified?
Your Honor, so to be clear, the state did not bring things to do another evidentiary hearing since we did have the no bond hearing.
Okay.
I just want to make that clear because then now it's already been established by proof evident presumption great that there were new felonies committed while on felony release. The concern the state has now is that Mr. Myers, while he's in jail, is he's sending messages
He wasn't
to
convicted of any of these
other
supposed
YouTube
felonies.
people in order to ask them to live stream.
I mean, they weren't
He
even
then will
legitimate
call
charges.
them so that they can then live stream him from the jail. And in doing so, he is now calling upon the followers to essentially continue to harass people involved in this case.
Objection.
Hold on. She has the floor. Go ahead.
So that includes that he's calling on them to contact the court.
He hasn't been
In his
indicted
words,
for
he
any
said,
of these new felonies. That's
Don't
what I meant to
interrupt
say.
her.
I meant to say he hasn't been indicted for these supposed charges while on felony.
She's talking. Just wait till but you just got to sit.
Remember how I had to wait the entire time?
Yeah,
And
I
I only got
Yeah.
the chocolate.
My
Okay.
ADP kicks in when I hear lies.
I had the floor almost the entire day during your bond hearing when it was my turn. That's kind
Okay.
of how it works. You take
Go ahead, Ms. Stiles.
so he's called on his followers to roast the court. He's been going through things. He's been reading things from the grand jury transcript, which is also protected by statute that he's not supposed to be reading from the grand jury transcript. And so he's putting all that information out and it's going out into the public. And what I am concerned with is we want to maintain the integrity of this case and in the integrity of the trial that's going to likely take place in this case. And with him actively going on and live streaming, he's continuing the same behavior for which he's in custody now. So it's putting the victim is continuing now to get harassing emails and voicemails. And we are having issues with everybody involved in the case where they're trying to intimidate people in the process to influence the case, which is improper. And so I have concerns about his access, at least to, I take very seriously somebody's ability to communicate with people when they're in custody. But if he's using that ability to communicate as a weapon, that's going to harm the integrity of this trial and harass the victim and harass the people involved in this process, then I don't think that he should have that ability to do so. So I am asking for his ability to be the restricted, that he not be able to live stream from the jail.
Can't do that.
And if he is not able to comply with that, then I'd be talking about the phone privileges. He still has the tablet, but I'm concerned with the live streaming.
So, what's the policy of the jail, if you know, for people in custody to use the telephone?
So my understanding in inquiring from them is they can't use the telephone, so they can't ask them to be connected to a third party. So if they call person A can't then, three-way call with person B. It doesn't sound like the jail was prepared for this. They hadn't had this come up where he would call, person A and then person A would be live streaming him,
The news
on
does
the
it all
media.
time.
Don't-
The news does it all the time.
He's talking. Just be quiet.
If he's gonna let you
Go
argue
ahead.
for 10
And so it sounds like the jail's visiting that issue right now, but I don't know what they're doing with it. And if he wasn't doing it in a way where he's calling upon people to harass members of people who are involved in this case, and that is also causing the harm to the victim, I don't think it would be the same issue. But the problem is that is the very nature of what his conduct was that got him the criminal charges in the first place. And he's still, even though he's in custody, he's still using that means to cause harassment to the victim and harassment and intimidation to everybody involved in the process. And so that is my concern, is he's posing that ongoing danger to the victim, and he's causing the implications for the integrity of this trial.
There
So
is
what
no
would your
integrity
remedy
in
be?
this trial?
So I would ask for an order that he not be able to participate in live streaming, and then that's where I would start. And then I would hope that if he was ordered to do that, he would comply with that. And then then that would also give the jail, if they find out that he is live streaming, then they could then take action to stop it as they needed to. I think that's the least restrictive of the options, because that way I don't want him to lose his phone privileges where he can't communicate with people. But I want him to not be live streaming about this case, causing that further harassment. So like I said, I believe if the court restricted him from live streaming on it, then that would allow the jail to take action as necessary.
All right, Mr. Myers, your response.
Can you pull up I don't have the computer. Can you pull up Rule 3.6 of the Model Rules of Professional Conduct, Trial Publicity? Thank you.
Lane is not responsible for the actions of other adults unless he's telling them to do something that's against the law.
I want to start there. Rule 3.6, trial
Yeah,
publicity.
hold on. I'm getting there.
He was going to look it on his phone, that's what I was saying.
What was it?
Rule 3.6, trial publicity.
All right. A lawyer, this is 3.6.
Yep.
A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make any extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicated proceeding in the matter. Notwithstanding paragraph A, a lawyer may state the claim, offense, or defense involved, except when prohibited by law, the identity of the persons involved, information contained in the public record, that the investigation of a matter is in progress, the schedule or resulting steps in the litigation, a request for assistance in obtaining evidence or information necessary thereto, a warning of danger concerning the behavior of a person involved, where there is reasonable to believe that there exists a likelihood of substantial harm to an individual or to the public interest, and in a criminal case, in addition to subparagraphs 1 through 6, the identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in the apprehension of that person, the fact, time, and place of arrest, the identity of investigating and arresting officers or agencies, and the length of that investigation. C, notwithstanding paragraph A, a lawyer may make a statement that a reasonable lawyer would believe is required to protect the client from substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. No lawyer associated in a firm or government agency with a lawyer subject to paragraph A shall make a statement prohibited by paragraph A. That's the rule.
Yep. Can I go now?
Yeah.
All right, so as we can see right there, I can talk about information contained in a public record, police reports. I can state the claim, how I plan to defend it, the identity of the people involved, the scheduling of the litigation, what happened at my last court date, hey, can anybody help me, information or assistance. I can warn the public that the person who's putting these charges on me is a danger to the public because they don't know they're a government employee. I can say that in a criminal case, I can talk about the identity, residence, occupation, and family status of myself. I can talk about myself. I can talk about the facts, the times, and the place of the arrest. I can talk about the cops who came to the court and testified, the arresting officers, and the most important, though, C, a lawyer may make a statement that a reasonable lawyer. For the purposes of this discussion, as pro se, we're calling me a lawyer, right?
Yes.
Okay. So, especially C, a lawyer may make a statement that a lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Well, I sure didn't put these charges on myself, and I sure ain't out there telling everybody that I got my slap. How did they know my slap got denied? Somebody leaked it. So how am I not able? I am allowed to correct the public record. I am allowed to say, I know they're accusing me of this, but it's not true. I'm allowed to defend and I'm allowed to say.
There's a difference between what you're saying and what's being alleged.
But what's being alleged?
Hold on. What's being alleged is that you are giving information encouraging others.
But that's not true.
Harass.
That's not true. Where's the evidence? Where's the evidence? I have never, ever, and that's what you're going to find out, especially your little slap motion. I've never, ever in my entire life told anybody to contact this woman under any circumstance. In fact, I made 2 videos saying do not contact Shannon Walker. And we're going to play that at trial. Okay? I've made it explicitly clear. People can She forgets that the First Amendment, people can address the government. People can call you on your government phone. That's why it's listed. Okay? That's up to you to decide, not her. She doesn't want me telling people to call the judge. Well, guess what? Take your number down. There's no crime in calling the judge. That's why your number's on there. It's the First Amendment. This is all they want to retaliate more against me because I'm having the public participate in making sure the whole world knows how innocent I am. I'm allowed to go on the news. People do interviews from jail all the time on the news. All the time. People give interviews that are broadcast on the news all the time. I've never one time told anybody to contact the victim, alleged victim, Shannon Walker, whatever we're calling her, which won't, because I'm being charged for saying her name in a court hearing. So I don't even know what I'm allowed to say and what I'm not. But the most important part is she has no proof. She literally just came in here and said all that and doesn't even provide any proof. Show me right now. Why am I not charged then? So if I told everybody to contact the victim on a live stream, why am I not being charged? Because it's never happened. I've never in my entire life told anybody to contact this woman at any point in my 42 years on earth, okay? So for her to come in here and say, oh, he's on the live stream, I have the right to do that. I can go on there and say, hey, friends and family, I'm doing all right. This is what happened at my last court date. This is what's going on. This is what I'm going to use for my defense. This is what the evidence is. This is all under a bar. And that's what you should have saw in my slap motion. A bar attorney, a member of the Bar Association could hold a press conference and say, yeah, we got these police reports, and they say, yeah, he's her ex-boyfriend, even though he's not her ex-boyfriend, and we want to make sure that we let the whole public know that at no point were they ever in a relationship, despite a police report being signed under the penalty of perjury, that it says that I'm her ex. So obviously, you signed a police report under the penalty of perjury that I'm her ex. I have the right to go on to tell the public I am not her ex. That is not a crime. But I'm being charged for making a video saying, I don't know why it says in the police report that I'm her ex. I'm not her ex. I've never even met this woman. So I absolutely, can you pull that back up? Specifically to correct the inaccuracies of the public. If people are out there thinking, this is his ex and he's harassing her. I mean, how am I charged with domestic violence? I've never even met this woman. This is insane.
I don't think you're charged with domestic violence.
Of course I am. It says right here, 3 counts of domestic violence.
Hold on. I have the indictment.
The only time
The new charges that we went to court yesterday, I'm charged with 3 counts of domestic violence.
I have the indictment right here. You're
No,
charged.
not the first one, the new one from the 2 days ago.
I don't have the new indictment.
It says that I'm charged with 3 counts of domestic violence. I've never even met this woman. So of course I'm going to go on there and say, how am I charged with domestic violence? I've never met this woman. It's not domestic violence. I've never met her. So if I'm holding a court document with my name on it, it says you're charged with 3 counts.
Slow down.
That you're charged with 3 counts of domestic violence, and I'm saying I've never met. It looks bad. Domestic violence is a terrible thing. Harassment, all that. I'm literally holding an email right here that says, this is from me to Matt Walker, months ago. I do not condone those crazy messages in any way. I had no idea those were being left because I wasn't the one leaving them. I don't know the tone of the voicemails because I didn't leave them.
I'll be right back.
I do not encourage or agree with that and would never want my wife to get those either. Talking about crimes is way past what we are doing here. I'm talking about crimes. Alleged. I am going to make a video addressing anyone calling on my behalf. Better not ever do that. Or they should
Slow down again.
Sorry.
The court reporter's got to take down what you're saying.
All right.
All right, so we're getting far afield. Mr. Myers,
references to
Mr.
that.
Myers, we're getting far afield here.
Well, no, she's trying to take away my ability to talk about my case and talk to my supporters.
I'm trying to ask you questions to be able to make a decision, and you're just talking nonstop. So let's focus.
So you want to do like a back and forth?
Let's just focus. Yeah, Mr. Myers.
Well, I had a couple more points.
Hold on. I want to ask you some questions. You've talked like nonstop for several minutes now.
I'm scared. I don't know when you're gonna cut me off.
I'm not going to cut you off. I just need to talk.
Go ahead.
We need to focus. Okay?
I'll hold my hand or point at me or something.
So here's the question. Do you know, first of all, that I'm assuming that the jail is recording all your calls?
Of course.
And are you saying in those calls that you're not making any statements to anybody to encourage them to contact the victim?
Never, ever in my life have I
Okay.
ever told anybody,
So-
whether in jail,
All right,
whether 6 months ago, whether
Okay,
today,
I
tomorrow,
understand.
or the next day.
I have your point. So let's hear from Ms. Stiles to see what her position is on that, okay? So that's you've said that you've never done that.
At jail.
In the jail calls, right.
So so just want to make sure we articulate this properly. You're asking me, because she said that I'm making statements on live streams for people to contact the victim. Never, ever.
Okay.
So do we use the word lie, or do we use
Hold
the word
on.
manipulate?
I
What do we
want to
do?
hear. I want to hear what she has to say in response to that. So now Ms. Stiles has the floor, and you're not going to interrupt her while she
Sure.
talks. Go ahead, Ms. Stiles.
So, Your Honor, as far as the victim, he's not saying directly call her, but he's making other statements, and his discussion is encouraging that same contact. And then I would note that he's communicating with a YouTuber who has the victim's information posted on his page constantly. So when he's live streaming with him, and maybe Mr. Myers does not know that the person he's communicating with is keeping up her contact information. But so he's doing the live streams, and then that is then encouraging that contact.
Um,
And then as far as the court reference, he has absolutely told his followers to roast the court.
is that the word he uses? Roast.
Roast, yes. He provided a description
Thought we were talking
of,
about
Let her talk. Let her
he
talk.
provided your description. He was giving your description to this YouTuber that was being live streamed. He was making sure he was directing the website for the court so they would all know how to find your information to contact the court. And so that's where that is coming from. There are so many jail calls. I have not been able to go through all of them. But like I said, I have people emailing me from the public who have concerns about the information he is posting on these live streams, and they are reaching out to me and concerned for the victim. And then the victim is also continuing to get harassing phone calls and emails. And so that's where I have the concern. There's also the information about, my office, but that's not the concern I have with the trial itself. My concern is reaching out to the court and, of course, harassing the victim.
my turn.
All right, hold on just a minute. So I'm inclined to have a hearing on this on Tuesday, if we could, where you could bring that information in and we would have a record then.
Yes.
Mr. Myers, I'm inclined to hold a hearing on that.
Can I say something real quick?
Yes.
Not only is she, whatever you want to use the word that we don't use in court, we've went out of our way to make sure that any live stream, not only that, we paid YouTube money, sir, to block the word Shannon Walker. So at no point has any live stream I've been in from the jail used her name. You can't even, we paid Google because we're so worried about them doing this crap that my live streams, we go out of our way to, because, a live stream, because you might not be
This is
up on the
all
technical
about
nomenclature of like
saying
YouTube live
her
streaming
name.
and shit. So I'm
What's
going to give
her
you like a
name?
little technical jargon,
Shannon
okay?
Walker.
So when you're doing a live stream, right?
Walker
You
is
go
her
on
name.
YouTube, there's a
Can't
live
say
stream,
it.
which it includes like a little chat, right? There's like, so people, like whatever you're watching, people can kind of like comment down in the corner like, oh, right. We've paid YouTube money to make sure that the words, we put banned words, Shannon Walker, Matt Walker, all this kind of stuff. We paid YouTube to make sure that because we know we know they're watching. I would be an absolute moron to sit there on a live stream showing the victim's information. And that's not what, now, she keeps calling him my friend. No, she has the paperwork and she's about to get served with an injunction because she keeps calling a news media corporation registered in the state of Florida my associate, and she's been put on notice with a notice of claim already to stop doing that. And now that she did it again in this court, she will be hit with defamation, probably by the end of the day. And so you cannot, that is prejudicial, sir. She is trying to prejudice you against me by saying that I said call the court. No, what I said is before the slap motion, my wife, who used to be Judge Gordon's law clerk, said, if anybody wants to write a nice, respectful letter outlining why they believe this is a retaliation against public participation with the court, they can do so, okay? Nobody's encouraging the court to be rude to the judge or any of that. That'd be.
So, Mr. Myers, what I suggested is to have a hearing so we can hear this information.
Why didn't she come prepared? She's in here slanging mud on me and doesn't even have anything to back it up. I could come in here and just make up whatever then.
Because it just has happened.
Trying to prejudice you, sir.
No.
Why is she bringing up the court?
Don't talk over Mr. Myers. Don't talk over me.
Go ahead.
You gotta lower it down. It's not helping your case to scream.
There is no case.
Okay, there is a case. You're in custody, so there is a case.
For now.
So
for
Mr.
now,
Myers,
for now.
what I am suggesting is to hold a court hearing so that I don't want to argue about this.
I see what you're saying without anything like visually.
Yeah.
Right, and I want to say the scope of the hearing. You cannot bring in anything about the court because the court isn't accusing me of it. The prosecutor doesn't get to bias the court against me by saying that I said call the court. Your number's on the website, sir. I know you don't understand the difference between government information on a government website and personal information on a government website, but if people weren't allowed to call you, your number wouldn't be on there. And Rich Tracy's standing right there, and he gets all the emails and the calls, and nobody's been charged, okay? I've been dealing with you guys for 9 months, okay? I know the deal, okay? People been calling Judge Walton because she lied under oath. People been calling Judge Weiland.
Hold on, Mr. Myers.
She's attempting to turn the court against me and bias you against me by implying that I've somehow did something untoward towards the court. I said people are allowed to write the judge letters, good or bad. There could be just as many people calling saying Lane's a fucking idiot. He's with or without me. She is literally picking at needles in a haystack because she's so scared that I'm going to win this case because the whole world knows what's happening and she wants to take away all I have, my emotional support live stream where I go on there and talk about what I believe is happening to me. I would be an absolute freaking fool to go on a live stream that I know that every cop in Pima County is watching as it's happening and say, contact the victim.
Okay.
That would be suicidal.
So
Just to
what
take
you're
away
doing
his
is
freedom,
you're speculating
period.
on what's you know what's in the content because you're speaking. I don't know what's in the content yet.
The video you're saying at the live stream?
Yeah.
Yeah, I've never told them to do anything towards the victim. I've never said. In fact, this is what's really going to come out at trial.
Mr. Myers,
They
hold
keep
on.
alluding to this fact that this word encourage. How do you define Webster's defines encourage as? You can't silently encourage somebody. So for her to say,
Mr. Myers, hold on. We're getting far afield, and you're really, really amped up.
She's making false accusations.
No. She's saying that I'm suggesting to have a hearing, and she's going to bring this stuff in.
Well, why did she bring it today?
Because we just addressed it
at me and let it stick at the wall.
We're going to have a hearing. You seem very scared to want to have this hearing.
Oh no, I want to hear. No, I'm saying I'm scared. Okay. I'm not fucking scared of nothing, bro. I'm not.
Again, you're being disrespectful now.
Scared is the least thing I'm worried about.
You seem very scared to me.
Scared of the hearing?
Yes.
Bring
That's
the
why.
in.
What?
Play them.
Come on, now
Okay.
you're just escalating.
If I
Mr. Myers.
All you have to do is make sure that there's nothing temporary until the hearing. As in you can keep doing what you're doing.
right,
That's all you have to ask.
there's nothing.
All you have to ask for.
I'm not scared of anything because I know I'm not doing
Mr.
anything
Myers,
wrong.
Mr. Myers, just request that you can keep doing what you're doing until the hearing.
My frustration, what you're calling might be scared, my frustration and my.
Myers.
I want a second. What you might be taking as scared, I'm definitely not scared. These charges are bogus. What you're referring to as my apprehension or whatever you want to call it.
Scared.
I'm saying like you're calling it scared. I'm not going to use that word because I'm not scared. It's more frustration that if you're going to come in here and accuse me of making a live stream contacting the victim, you should be prepared to show the judge that. If you're going to come in here and make allegations that I'm telling people to do this or that to the judge, she should be able to show that right now. We shouldn't need another hearing. She should have came prepared to back it up with receipts.
That wasn't the purpose of today's hearing.
Then why are we talking about it?
Because we're going to set another hearing because you raised the issue. But this isn't the evidentiary hearing today. You got to. We talk about getting preparing things and then hold a hearing on what we're going to show.
She prejudiced me by stating it. You allowed.
He hasn't prejudiced you yet.
Told me she just stood here in open court and said that I told people to contact the victim, and then when you went back to her, she said, "Well, actually, he didn't actually say to contact the victim." So which one is it?
So, Mr. Myers, again, you seem very apprehensive about me setting this hearing.
No, I didn't understand what you meant about a hearing.
Mr. Myers.
Set the hearing. As long as
Okay.
how
about
status quo remains? Status quo remains.
Mr. Myers, just I know why you're nervous.
I'm not nervous. Stop saying.
Okay.
No.
Mr.
I'm
Myers.
not nervous. Okay.
Nothing changed.
I'm not nervous.
Make that one request.
Calm down.
Just ask
Calm
The
down.
status quo needs to remain in place. And we'll find out at that hearing who's lying, me or her.
That's all I had to ask for.
So I'm going to set the hearing at Tuesday at 1:30 p.m. if you all can appear then.
Yes.
All right. So that hearing will be Tuesday at 1:30 p.m. and that's on the ability of the defendant to make statements from the
You
jail.
can't take that away from me.
That's what the point of the hearing
It
is.
doesn't matter if we have 10 hearings. You cannot stop me something that the Bar Association gives me the right to do.
So,
At the hearing.
Mr. Myers, I get to make decisions. If you don't like my decisions, you can go to the Court of Appeals. That's the system. You can't threaten me like
I'm not
that. You did threaten me.
With what?
You just said that I can't make a decision.
No,
You
I
said,
said you can't take away my ability to talk
Okay.
about my case. It's literally a Bar Association rule. You would be in violation of the ABA.
I can do that.
You gonna put a gag order?
I didn't say I'm going to, but I can.
No, you can't.
Yes, I can.
You can't. I'm my own lawyer. You can't
But-
take away my ability to talk about my own case. You're getting into uncharted
Again,
territory.
you're threatening me again.
I'm not threatening.
You are threatening me.
How am I threatening you?
You're saying I can't do something when I can.
You can't.
Okay, so that's another threat.
It's my belief. It's not a threat. It's my belief. Why then? What is the Bar Association
not
thing
a
we just
threat.
read? Are you saying that
I
you
get
can
to-
overrule that?
Yes.
Okay,
How is
then
that
that's
a
my
threat?
misunderstanding.
Right.
It's not a threat. It's a misunderstanding.
Okay. And if you don't like my rulings, you have the right at any time to file a petition.
But I don't even have a pen and paper.
Mr. Myers, I just told you. You have the right if you don't like
just
any
told me I was
hold-
scared.
Hold
What do y'all
on.
think?
You
You
were
think the
scared.
I'm not scared of anything, bro. That's what you don't understand.
Okay, so hold on.
I'm definitely not scared of these bullshit charges.
Hold on, Mr. Myers. We're getting far afield here. If you don't like my rulings, you could file a petition with the Court of Appeals saying Judge Metcalf made a mistake, reverse him, then it comes back to me, and I file that Court of Appeals ruling.
What do I file when I don't agree with the prosecutor's lies?
I mean, if the judge thought that was a threat,
You,
then,
you bring something up here.
I mean,
So do I have the
Who knows
ability
what
to
they think
request
harassment
hearings
is.
also like she does?
Of course.
So I can bring up, so is that something I just send you in the mail or something?
You have to file a motion.
Yeah, because it seems like
You're very good at filing motions, Mr. Myers.
from home with Westlaw with my wife who was a law clerk for a federal judge and Judge Gordon, yeah.
All right. So, what, are you still married?
She,
What, she can't still help you?
from jail?
that was a low ball.
No, she's not my
That's a
attorney.
low ball.
Okay.
She has a job,
All right.
Because
and they already got
his
her fired from one of
relationship-
them.
So,
I guess doesn't go
Mr.
through
Myers,
also-
we're going to have the hearing
That was a
at
low ball
Tuesday
by the
at
judge.
1:30.
Determine if there's truth to their statements about me telling them
That's
to contact
try
the
to get him
victim.
emotionally
Correct.
upset because he knows
or to
he's
harass
susceptible
people.
to that.
Remember, this
Harass
is
people.
harass.
What does that mean?
There's a
Oh,
statute.
you can't that's legal jargon.
It's not. It's defined in the ARS.
Jargon.
It's not. like-
Tell me my
No.
conversation is harassed. You're not a law enforcement, and tell her she better come with some indictments
All right.
on Tuesday.
Ms. Stiles, anything else?
Your Honor, I don't know if the jail needs you to order that he have access to the law library, but we want to make sure
Okay.
that that's
Yeah, they
clear.
said I need a court order.
All right. I'll order that you have access to the law library in this
On both?
CR.
On the CR that I was originally, like the 14 counts and all that, right?
Correct.
But there's so is that going to change now? Because you already gave me that and they wouldn't take it, and so
It's in the order. It'll be in the minatory.
so then because the COs just get mad when I try to argue with them.
Well, maybe you shouldn't argue with them. Just talk to them politely.
I said I have a court order. They said no, you don't.
Mr. Myers, yesterday, they didn't want to let me in.
See what I mean?
I talked to some supervisors. They understood why I needed to meet you, and they made exception for me, even though there's a lockdown.
but that's
There's
him.
a lot you can do by
I don't
just
get
being
to.
calm.
I don't get exceptions at the jail. I'm wearing orange.
Okay. There's an order in the minatory. Anything else we need to discuss?
Your Honor, just that I think that last time the court didn't make a specific order regarding the law library, but now that order is specific to that should hopefully allow him the access with the jail.
Okay. And Mr. Myers, I'm going to continue to raise this throughout these proceedings. The way that you're behaving today, if you behave that way before the jury, they won't like that.
I
And
don't need legal advice from the
okay.
judge.
Well, I'm not giving legal advice. I'm just making an observation.
All right.
And that's something you need to keep in mind. And I'm going to keep reminding you about that, about whether you want to represent yourself or not.
So I'm not supposed to take that as you being condescending.
I'm not being condescending. I'm just saying the way you're behaving today would not benefit
Jury's
you.
not here, are
The
they?
judge isn't helping.
They're not here
They're
today.
not helping.
So I'm a pretty intelligent guy.
Okay, that's good.
Your Honor, then one question. So I'm obviously going to have exhibits for the Tuesday hearing.
Uh-huh.
I just don't know how to get those to Mr. Myers because he also has Mr. Parvin as his attorney. So because we're going to have jail calls, we're going to have the YouTube videos. So
This is ridiculous.
Can you guys?
Hold
Can
on.
you guys
Am I
hear
being
me
charged
on
with
this
these crimes,
while
or is this
audio
just
is
to
going
taint
at
the
the same
judge?
time?
Can you reappoint me for that
What's
one
the
hearing
sound
only?
quality
here.
on a
We're
scale
here.
from 1
Will
to
you
10
let him
when I'm talking
be my
into this
lawyer for that hearing
microphone?
only?
How well can you hear me?
Well, let's talk to Mr. Parvin first of all about how you think we can get this information to Mr. Myers. Do you have an idea?
Which information? Well, obviously today I printed out something that was just sent to me. I was able to give Mr. Myers. Anything paper's not is as long as the jail's not on a lockdown, it's pretty easy to get it to him. When it's a lockdown, it's a lot harder. Unfortunately, there's a lot of lockdowns for the jail lately. But for media, that is a lot tougher. I can get permission to go down with a computer or phone. So as long as it's monitored, they'll let me use the media to show him as I show him what I'm. But it is hard to give him actual media unless he can go to the law library and download himself.
Hold on, Mr. Myers. Can you go there with your computer? Can you bring your computer in with you?
My currently my phone has everything. That's where I download my audio. They don't like phones, but they usually allow it if there's a special. I'll say I need to show my client something. They will let me bring a phone for that purpose to show them audio. So that's where I download most of it.
Okay. Ms. Stiles, any thoughts?
Just normally the attorneys are able to bring a computer and do not have a laptop.
Since the technology is so much easier to just use my iPhone and plug everything in and just play it on screen. It's been great.
So maybe that's, Mr. Myers, would that work if your client, your Mr. Parvin had the disclosure and he could go to the jail and just play it for you? Go ahead.
That's and I actually saw another attorney with the phone at the jail recently, so I know they must be making exceptions some of the time.
Not sure what the lag is.
Times are changing.
I want to clarify something about the scope of the hearing, because it went from live streams to jail calls. Now, you definitely ain't going to tell me that my private calls that they're listening to that aren't broadcast, those have nothing. That's outside the scope of the hearing.
No, it's your calls with people on the outside.
But she said live stream.
So,
Well, my understanding is that you're calling someone and the person on the other end of the phone is then live streaming that. You're obviously not live streaming from the jail because you don't have access.
Right,
to the
no,
computer.
they're recording me too, though. I'll call, and we'll have it just like a news interview with K-Gun 9, and then K-Gun 9 will broadcast it.
Right.
That's not illegal.
So the question is whether you can continue to have access to make those calls.
in Your Honor, so what I'd be intending for the hearing is he both sends messages to people to say that he wants to live stream, and then he goes on the live stream. I just want to make sure we have pulled a lot of those videos already, but in the event that they take them down before we have some of them, then we have the jail calls. But in the jail calls, he references and he asks them, are we live? And so that would be where if for some reason they pull down the video, I can then bring in the jail call to show that he actually was telling them and knew that he was streaming live with them.
Okay.
Why is that a problem?
That's what the part of the hearing is. We're gonna hear the evidence and then we'll make a ruling.
Why would it be a problem that I talk to my family on a live stream? Because calls are expensive. So why can't I call one person and talk to multiple people? You can't.
The question is whether you're doing that to harass people. That's what that.
No, that's what law enforcement decides.
Hold on,
The judge.
No.
So you're gonna make a legal finding of harassment?
So again, you're threatening me. You keep threatening me.
I asked you if you were gonna make a legal finding.
I haven't heard the evidence yet.
But no, I'm saying your inclination is that you think that so if you decide that you feel I harassed them, will I be charged?
No.
Then it's not a legal finding.
I'm not saying it is illegal to find it, but
You said it was harassment. Harassment is a crime.
Hold on.
You can't harass somebody and it not be a crime.
Hold on.
It's either a crime or it's not.
Mr. Myers, you got to slow down again. We're going to have a hearing on whether you're using the system to harass witnesses or victims.
That's ridiculous for you to even say that.
Again, you're threatening me.
By saying that's ridiculous, by my opinion.
It's disrespectful.
No, I want the hearing, but I'm saying the fact that
threat?
this is the rabbit hole we're in right now is an embarrassment to the entire American legal system.
Okay. And if you think that my ruling,
People make rap videos
hold
from jail. They literally rap albums live on the jail phone. They literally talk into the jail phone and make music that's then published for monetary gain. Every day. People write books from the phone.
Mr. Myers,
No, I don't like you accusing me of harassment.
Hold on.
Flat out. Because
Well,
you
hold
don't even
on.
know what harassment is.
Hold on, Mr. Myers. We're going to have a hearing next
To
Tuesday.
determine what?
Whether you're using this system to harass the victims.
You cannot use the word harass.
I
Because it's
can.
not a legal finding.
Again, you're threatening me
Oh,
again.
you're saying that I'm committing a crime.
I'm not.
You-
We're going around and around. I've already
So you're
discussed this.
saying you're going to find if I'm
That's-
using
hold on.
the phone to
That's
harass
that's not
people.
enough time to prepare for that hearing. You need disclosure of the jail
I
policy.
need disclosure of the jail policy. We need more time.
Okay. No, I'm not. We're going to set this because they've asked for me to do this today. I'm giving you a hearing already. So I'm not
Determine
going
if I'm harassing them.
Yes.
And you're going to make that determination?
Yes.
Are you a cop?
No.
Then how can you make a legal
All right.
conclusion?
You're being disrespectful again, Mr. Myers. You are.
Maybe you take
All
a
right,
second and
all right.
explain to me what
Pretty
you mean.
soon, you're hold on, Mr. Myers. You're getting to the point where you're being so abusive that I'm not going to let you represent yourself. You gotta calm down. You're going. No, we're done with this. So we're going to be back here at 1:30 on April 1st, and we'll make that
That was second.
April 1st.
It was the first.
the first. I'm sorry. Yeah, Tuesday.
So that's the.
I'm sorry. Hold
That's
on.
the first.
April 1st, Tuesday at 1:30. I apologize if I said the wrong date.
Why am I heard?
Okay, and then Mr. Parvin, you're going to bring the your phone in with those things
Yes,
recorded.
and I'm going to talk to him, especially since I'm sure the jail can see in the order. He needs to see this. I want to use my iPhone. It's the
Yes.
big iPhone, has everything on there. It plays everything great. I want to show him that.
All
I
right.
do have concern. Some of the disclosure, I mean, I could see any videos I know might have been live streamed, but some recent jail calls were disclosed. I was not able to download those files. But I'm assuming it's
Okay.
the same as what I already have. I don't know what that recent disclosure was.
So the recent jail calls go up until today's date. And so he's been getting the jail calls as we're getting them in.
Okay.
And then we're also disclosing the videos that go along with
Got
those
it.
jail calls.
Different because I'm having a hard time downloading the jail call because you have separate quarters. That didn't play. All the videos played, but not the jail calls. But if it's the same, it's not an issue.
Well, and I'm happy to speak to Mr. Parvin to make sure that he has everything that we're going to be using at the hearing.
So we're going to sit here for like 5 hours and listen to jail calls?
No.
Then we're not going to get a true hearing and I'm not getting due process.
All right. You
So
can
they
make
can
that
pick and
objection
choose.
then. Again, you're threatening me.
What?
Here's what's gonna happen. I'm not. It's a mixed case because I'm appointed on one but not the other case. So I'm guessing. Well, this could be a mutual. This is not for the second.
All right,
case, so I'm
who's
not
scared?
hearing at
Is it the
next hearing. That's
judge
what I'm wondering.
or is it Lane Myers?
For this hearing is
scared?
just for this first case we're here today.
The
Not
one
But
who's
you're-
claiming the
you're,
other's threatening him.
Your
Advisory.
advisory
Okay.
council.
But I could show him, I could get disclosure and still show him the media from my phone until
Right.
the jail can make arrangements to have him download it in the law library.
Right. So I'm going to order and have the minute entry reflect that Mr. Parvin is given authority to bring his phone into the jail to show the disclosure to Mr. Myers. And in my release order, I'm also ordering the defendant to abide by all previous terms and conditions of release. All right. So we're going to be back here on Tuesday the 1st at 1:30. And Mr. Myers, again, if I find that you're just being so abusive that you are unable to speak properly, I'm going to find that you can't represent yourself and have Mr. Parvin step in. And then if you continue to be disruptive, I can order you not in the courtroom. Your proceedings can occur without you here. I don't want to do that, but you got to behave yourself. Yes.
Would it be possible so that me and you can get on the same page for you to maybe give me a short list of do's and don'ts or something? Because,
It's not that hard.
I'm the common man. I'm not a legal, I don't speak legalese.
Mr. Myers, I'll tell you, I have 300 cases at a time. I have sometimes 20 to 30 hearings in one day. Most people, even if they're charged with very heinous crimes, are able to behave themselves in the court. Well, they're able to behave themselves in the
If you're
courtroom.
innocent, it's different.
Some people are acquitted and some people are convicted.
Oh, innocent.
What I'm telling you is, Mr. Myers, that most people are able to behave in the courtroom, and you're having a very hard time doing that. You're very argumentative and threatening.
I take offense to you keep calling threatening is a legal term again. Threatening you by saying what?
Okay, Mr. Myers, I've given you my admonition. I can pull your right to represent yourself if you can't behave yourself.
But no, that's why I asked you if there was some
Right.
way that we can maybe is there rules of court decorum or something I can read somewhere so that I can?
Mr. Myers, I just told you, I have several hundred cases,
That's not me.
and I know, but everyone else is able to follow a normal.
Everybody else is innocent and is not innocent.
There, people are charged who are acquitted.
And I didn't say acquitted. I said
And everyone who's charged is presumed innocent until a jury finds them guilty or they plead. And so it's the case that the average person who is a defendant in a case or a witness or a lawyer or anybody can behave themselves in court, and you're having a very hard time. And if I make a finding that you're so abusive and obstructive, then I can pull your right to represent yourself, and I can exclude you from the courtroom if you cannot behave. So you need to keep that in mind.
it's hard to be innocent in an orange jumpsuit.
All right. We'll see everybody at 1:30 on.
So what about the modified conditions thing?
I just affirmed
So
previous
like,
risk conditions.
so there's, you know how the modified.
I just told you that.
Motion, the amended, all that, we move past that now or what?
So you're held in $500 bond.
So we.
Affirming
modified
prior
it, whatever.
release conditions.
Right, okay. So the motion that they filed, the motion, then I responded, and then we were gonna come here and have today's hearing about, we've completed that portion?
Correct.
Okay, and it ends with me having a $500 bond?
Yes, and affirm current release conditions.
Okay.
All right.
That were previously,
Correct.
okay.
Tuesday, April 1st at 1:30 p.m.
To decide whether she's lying or I'm telling the truth.
We're pushing it.
Wow. So you guys heard it. That was the hearing to keep Lane Myers, determine whether or not he should stay in jail. They revoked his bond, which they should have let him out on bond, since all of his charges are nonviolent charges, and he's not a flight risk. So they kept him. My understanding is they're keeping him in jail at this very moment. He was pulled out for this hearing. That was live, what you just heard. An actual live hearing. And he's going right back to his jail cell. But my understanding as to the reason why Pima County, Arizona is keeping Lane Myers in jail is because of him, I guess, accumulating 3 more felony charges while out on his felony bond, if I'm getting the terminologies and stuff correct. But my understanding is that these supposed felony charges, he has not even been indicted for. Therefore, that should not have been used against allowing him out on bond so that he can better defend himself. I mean, this guy has, gosh, I don't even know how many charges at this point. That was Lane Myers. He is the victim. I can understand why he wants to jump in and why he's, blurting out certain things. I would advise him, my only feedback for Lane is, maybe calm down a little bit. We got to understand this is an innocent man who is, fighting a corrupt county, Pima County, Arizona, against these bogus harassment and stalking charges. Last I heard, he had like 33 charges or so altogether. And I think like 7, 8, 9 of those were felonies. And again, this is all based on harassment and stalking as it relates to one person. I believe it's just one person. It might be others, but I think this is all centered around a woman named Shannon Walker. And he's posting her information, or has posted his information apparently on his YouTube channel. And people are calling and petitioning their government, which is a First Amendment right, redressing their grievances based on the outrage this is causing to the general public. But this information he's sharing of Shannon Walker, her phone number and email, it's listed on a .edu website, a government website, public website. Anybody can look this up. I'm actually on the website right now. You can go to law.arizona.edu just to provide the proof here. You can go visit it yourself, see that I'm not making this up. You'll see her picture when you pull that up. Actually, I'm sorry. I went to Google. I typed in Shannon Walker, University of Arizona, and it brought up a page where on this page, it's her picture, and right above her picture is her contact information. So that's where he found it. It's open to the it's public information. Why isn't the University of Arizona charged with harassment or stalking? I mean, he got it. Lane Myers received the information from the University of Arizona. So this is all based around the supposed harassment and stalking of a woman named Shannon Walker. And every time Lane Myers says her name, whether it be on YouTube, in a voicemail, and I think this all kind of started over a voicemail, which was a non-threatening voicemail, by the way. And I am going to be making a video about this. I'm working on it currently. I have the thumbnail made, and I'm piecing together some highlights and things just to kind of catch everybody up in the community with what's going on. I think this is super important. I kind of tuned out this drama for a while when it came to Lane Myers. I heard about what was bits and pieces about what was going on. It seemed to be very complicated to me to keep up with, and I sort of just tuned it out because I had other things I was working on and dealing with. So, but now that I've taken the time to kind of allow myself to kind of get caught up by means of speaking with another YouTuber, another channel goes by This Is a Public Service. Perhaps most of you know of him. He goes by Foshin. And, I've been talking to him, and this is ridiculous. I mean, this to me is an outrage. And not only that, but it is frightening. This is frightening. It should frighten you that this is going on in the United States of America, that you could be facing up to life in prison for hardly any effort at all. Didn't take much for Lane to get to this point. Yeah, to some people, he might come across as a little difficult to listen to. I get it. That's neither here nor there. The guy is a free American. I've seen people in the chat say this man has ADHD. I don't know if he does. Maybe he does. Maybe he doesn't. But I see an innocent man fighting for his rights. Yes, I believe he should cool down. He made his points that he wanted to make, but when he continued to allow the judge to escalate things by poking and prodding and trying to escalate the situation, knowing that Lane Myers is going to get emotionally brought out, and he's susceptible to that. Apparently, I don't know. Maybe these are my opinions, but I don't know Lane. I've never spoken to him. I don't think I've even watched any of his videos. Not yet. I've just watched some of the videos that This Is a Public Service has put out. I've attended some of these live hearings, and I'm just now starting to kind of wrap my head around what's going on with this gentleman. But apparently he is a target. He's a political prisoner, as you saw in the thumbnail for this live. He definitely is. I'm going to be getting into more details, explaining more of the situation. Just some of the notes I have here in front of me. Prior to this whole Shannon Walker situation that's led to all these charges, both misdemeanors and felonies, he had some other drama going on in Arizona, and if I'm correct me if I'm wrong, but he was 16-0. He was winning all the other cases, all the other corruption that the state was throwing at him previously. And then one of the more recent things before this harassment drama started with Shannon Walker, Lane Myers had basically made a prosecutor whose name is Matt Walker look really stupid in court. I mean, basically owned the guy in court. And from what I hear, Matt Walker has become the laughingstock in Tucson, Arizona. And so I guess at some point, let me back up. Matt Walker's wife, I guess at one point or another, maybe currently works at the University of Arizona. And Matt found out that Shannon Walker works there, who again is Matt Walker's wife, the prosecutor that Lane owned in court. And so I guess this all started with the voicemail. So Lane Myers reached out to Shannon Walker, got the information straight off of the government website, University of Arizona's website, and left her a voicemail. And I'm going to be playing that voicemail in the video that I'll be making, kind of catching everybody up. It's not going to be like an hour-long video or anything, although it could easily get to that. I'm going to try to condense everything to like, I don't know, 15, 20 minutes, 30 minutes max. But this voicemail kind of started everything. I don't know if there was any encouragement directly from Lane or not to for others to petition their grievances, but if he did or didn't, it doesn't matter. Lane is not responsible for anybody else's actions but his own. So even if there were legitimate threats that would fall into the harassment category towards Shannon Walker, then they should be going after those people, unless Lane Myers told people to go harass or say things that were legitimately harassing Shannon Walker. But he never did such a thing. He never said, go harass Shannon Walker. He never told people to, he never said anything about their conduct or behavior, how they should go about redressing their grievances with their government and with Shannon Walker, who, by the way, does not want Lane Myers saying her name. It seems like every time he says her name, even if he says her name like on the phone, in jail, he accumulates more charges. So Shannon Walker does not want us to say her name. Now, at this point, if it wasn't public record before, if we're going to entertain that for just a split second, regardless if it was or not before, it definitely is now, because this is a story that is unfolding, and it's public record. This is, the only time that Lane Myers has even been in the same room as Shannon Walker was in court, and all this is now public record because it's now the state is involved. So we can say her name all we want. There's nothing they can do. So say her name, Shannon Walker. That's her name. And you can't say her name lest you accumulate some charges, even felonies. This is absolutely insane and frightening that this is going on in the United States of America. I can't believe it. It's frightening. If it can happen to Lane Myers, it can happen to you. It can happen to me. It can happen to any one of us. This is why this is important. I don't care what you think about Lane and his personality and his supposed ADHD. I don't care. All I care about is, were his rights violated? And when you take a step back and you look at this from the outside, it's pretty damn clear they're trying to keep Lane Myers in jail for no good gosh damn reason. And it pisses me off and it frightens me. So anyway, if you want to redress your grievances, you certainly have a First Amendment natural right, God-given right to petition your government. It's protected under the First Amendment of the United States of America. If you do go petition your grievances or redress your grievances with your government, I would ask that you do it peacefully. And that's all I got to say about that. So some other notes I have here in front of me, I feel I should share with you guys here since we're on the topic. This all kind of started with, it started with a voicemail, but there was a civil injunction that Shannon Walker had filed against Lane Myers, which was based on a lie. And Lane Myers, quote unquote, violated the civil injunction, which was based on bullshit. And he accumulated 14 more charges based on this civil injunction, violating the civil injunction regarding Shannon Walker. Shannon Walker reminds me of, do you guys remember Christine Ford in the Kavanaugh thing? Remember Judge Kavanaugh and Christine Ford, was posing as like she was changing her voice to like a 9-year-old little girl and claiming that she was raped by Judge Kavanaugh, like back in the day, which we all know she was full of shit. Shannon Walker kind of reminds me of her in a sense. I don't know. What do y'all think? Let me know in the comments there in the chat. So anyway, 14 more charges. 8 of those were, I believe, if I'm correct about saying this, 8 of those were felonies for simply violating this bogus civil injunction with Shannon Walker. Some of you were asking in the chat earlier, I was taking note of, the bond was revoked recently. This was like 3 days ago. There was a hearing about this bond. It was revoked. This is where the judge said, "I need 10 minutes to review everything. I'll come back and give my verdict." And it took her like 45 minutes to basically say, "Yeah, we're going to revoke your bond based on these additional charges that Lane Myers picked up while in jail, while he was in jail kind of recently, based on phone calls he was having, I guess, with This Is a Public Service, mentioning or talking about Shannon Walker, saying her name." There might be a little bit more to that, but that's essentially what it boils down to. And Shannon Walker is the wife of a prosecutor there, Matt Walker, who was completely humiliated, and rightfully so, by Lane Myers prior to the whole drama that ensued with Shannon Walker, that Shannon Walker herself started. This is evil stuff. This is pure evil. We're looking at a minimum of 45 years in prison with Lane Myers, with all these charges that he's facing. He's looking at least 45, bare minimum. Now, the dude is already in his 40s, so that's basically a life sentence. Over a voicemail, or it started with the voicemail. He's left a couple more since then. But she's basically a public employee, possibly a quasi-public employee. Regardless, this is a story now. The state is involved. He's telling his story, and he's getting further whacked for it. And not just whacked, based on just, if you were to take out the context and the content of everything that has happened, and you just look at the sentencing possibilities, you look at what might happen to Lane Myers, 45 years to life, you would expect that to be somebody who unalived someone or did something heinous, abominable. He left her a voicemail that started all this, and putting out information that's already on the University of Arizona's website. Unbelievable. So yeah, he's picked up at least 3 more felonies while in jail. And the judge was using these felonies to revoke his bond a few days ago. And he hasn't even been indicted with these felony charges, if that means anything. It did go to a grand jury, but he hasn't been indicted, at least at the time his bond was revoked a few days ago. So that's the kind of catch you guys up on what's going on. This is a frightening thing. I'll post some more information in the description of this video once I end the live stream. So if you want to redress your grievances, I'll make it convenient for you. I just ask that you do it peacefully if you feel so inclined to exercise your First Amendment right and speak what's on your heart and mind. So with that being said, guys, thank you so much for your attendance here in this live. I'm kind of a noob at this OBS studio thing, so I'll get better at it. This is my first one, so I appreciate you guys bearing with me. Love you guys, and I'll look forward to seeing you in the next video. Until then, truth, trigger,